Good evening. I'm Harold Krent, and I'm Dean of Chicago-Kent College of Law. On behalf of faculty, staff, and students, I'm glad to see all three of you represented here tonight. I want to welcome you to this candidates forum for state's attorney. And it's so appropriate to have a candidates forum with everybody here at a law school, and particularly are gratified by tonight's focus on gender-based violence. It's not a focus that the press gives enough attention to, but it's one of the most fundamental responsibilities and important responsibilities of any state's attorney. I'm pleased to introduce right now Alicia Tate, who's Director of Programs at the Chicago Foundation for Women. Alicia was a former policy advisor for Attorney General Lisa Madigan. Before that, she was a publisher, editor, and reporter for the Chicago Reporter. Alicia.
Good evening.
Good evening.
Good evening.
Good evening.
Thank you all for coming out on this very snowy night. And thank you to all of our candidates for being here tonight. I think this is a really important evening because there's been a lot of attention on this race and on the issues associated with criminal justice around this race. And appropriately, a lot of that discussion has focused on shootings. Huge problem in Chicago, issue that's top of mind for many of us. But what has not been talked about as much, and the reason we're all here tonight, is that we have not heard as much discussion about gender-based violence. And just to put this in perspective, I know this was pretty shocking to me when I started working at Chicago Foundation for Women just a couple months ago to look at the sheer scope of the issue and the sheer number of resources that law enforcement dedicate to gender-based violence. So in Cook County, we have about 570 murders in a given year, and that is according to the Illinois Criminal Justice Authority. Not a small number, not to minimize the tragedy for all of those families and involved in communities. But 570 murders. Criminal sexual assaults, we had 2,000 reported to police in that same year. That was 2014. And if you look at what the actual estimated number is, according to the Illinois Coalition Against Sexual Assault, that would be closer to 6,000. So 570, 6,000. And then when you look at domestic violence calls reported to police, does anybody want to even hazard a guess of what that number is? 61,500. So over 100 times greater than the number of murders in a given year. So again, critical issues for all aspects of law enforcement in our criminal justice system, and that is why we are so pleased and grateful that each of these women are here tonight, taking time to talk with us tonight. So I just want to say a couple of housekeeping things, and then I will turn it over to our moderator, Susie Ahn. But let me thank Cook County State's Attorney Nita Alvarez, Kim Fox, and Donna Moore for being here. And I want to mention that this session is being recorded live by CAN TV. We want to thank CAN TV. So if you know people who couldn't make it here tonight, let them know that they can go to the website online, cantv.org/live. It'll be broadcast at a later date. And I want to thank all of our sponsors, the Center on Halsted, the Chicago Alliance Against Sexual Exploitation case, Chicago Foundation for Women, Chicago Metropolitan Battered Women's Network, Rape Victim Advocates, and our hosts, our special thanks to our hosts, Chicago-Kent College of Law and the college's Criminal Law Society. I want to remind all of you that CFW is hosting a reception afterwards in the lobby, so please join us to continue the conversation. And you can start this conversation as we're talking, as you're listening to the candidates online with the hashtags, #End Gender-Based Violence, that's #End Gender-Based Violence, and #GBV, Gender-Based Violence, State's Attorney. GBV State's Attorney. So please use those hashtags. We are going to be monitoring social media through the night, and that'll be incorporated into the questions that we submit to the candidates. So with that, I want to also thank WBEZ for allowing us to have the talents of the wonderful Susie Ahn to serve as our moderator. You may have heard her on Drive Time or in some of the midday programming, but she's a news reporter at WBEZ, and her work has been heard on NPR, CBC, and BBC. So with that, I'll turn it over to Susie Ahn.
Thank you. I want to thank all the candidates and all of you for being here tonight. I will try to keep my comments brief so we can get started. I wanted to point out to our audience the forum rules that you will see in your program. These are the rules that each of the candidates have been given, and they will adhere to this for the forum. Also, take this time to silence your phones. I know I should not say that. That should already be done. And please refrain from any applause until after the program is complete. Also, we will be taking audience questions, so those index cards that you got at registration, throughout the program, feel free to jot something down, and there will be volunteers in white shirts. If someone wants to raise their hand, volunteers. They'll be roving around throughout the program to collect any of your questions, so throughout the program, feel free to do so. Okay, so let's go ahead and kick things off. Each candidate will now make a 2-minute opening statement outlining why she is the ideal candidate for the Cook County State's Attorney. We have a timekeeper right here, and we'll start with Anita Alvarez.
Well, thank you. Well, thanks to everyone for coming out tonight to brave the weather, to come up and talk about this very important issue, gender-based violence. I'm happy to be with you and be back at my alma mater. It was actually this forum 8 years ago that I made the promise to the advocacy community about how things would be done differently in the state's attorney's office when I was elected. And I feel very proud to say that I have not only kept those promises, but have done even more to improve our response to gender-based violence. At that time, the questions were about mandatory training on domestic violence and the major issues we were having with certifications on U visas. Those were my first fixes when I took office. We moved on to much tougher conversations over the year, and I am proud of these conversations because many of the positive changes I have made came as a result of those very important conversations. These include a complete revamp of our approach to sex crimes, expansion of my sexual assault and domestic violence division, and increased grant funding coming into our community. I instituted mandatory sexual assault training for all assistant state's attorneys in order for them to advance to the felony review level where charging decisions are made on sexual assault cases. This training was designed in partnership with the advocacy community and experts across the entire nation. We still have challenges that we are working on each and every day. Acquaintance rape cases. They continue to be one of the toughest cases we are handling. This is because of the unique dynamics that those cases present. We see a high volume of drug and alcohol, especially alcohol-facilitated cases that are reported. There are often no witnesses to these incidents, and evidence collection still continues to be a challenge for us doing these cases. So I'm pleased to announce that we have received a 3-year grant to begin a specialized campus initiative in Cook County where we aim to address dating violence, sexual assault, and stalking of
That's
students.
time.
So thank you, and thanks for coming out.
Thank you. And now Kim Fox.
Thank you. Good evening, and once again, thank you all for braving the weather to come out this evening. We are facing really unique challenges here in Cook County around our criminal justice system. As Alicia said, that we have an issue related to gun violence in Cook County, but the issue of sexual and gender-based violence cannot be undervalued. As we go around and look across the country at the issues of campus violence, we have here in the city of Chicago a number of college campuses that are dealing with the issues of underreporting of sexual assaults and the prosecution of sexual assaults on those campuses. That there seems to be a disparate way in which these cases are being handled both internally and with our state's attorney's office. The underlying concern is largely that we have a number of these cases that are presented to our felony review unit, and a small number of those cases are in fact being prosecuted. While we understand that sexual assault cases are difficult to prove, oftentimes it is the voice of one person against another, the victim against the defendant. But the way we investigate these cases should be not from the proposition of making sure that the victim is not lying, but from the proposition of making sure that there's a case that can be prosecuted. It is oftentimes, the best case scenario that we have every bit of evidence, DNA and the like, especially in this era of CSI, in which we can go forward on some of these cases. However, the sad reality is that we have the evidence that's presented before us, and oftentimes it's one-on-one. But the value of placed in believing victims and believing the circumstances for which they appear before you, and ensuring that all of the services that you are providing and the investigation of those cases are aimed towards making sure there's sufficient evidence and the ability to go forward to prosecute. We have those challenges here in Cook County. We need a state's attorney who's committed to dealing with those issues. As one who has been the victim of sexual violence myself, I'm deeply committed to these issues in a personal way, and I'm committing my term to dealing with these issues in an innovative and thoughtful approach. Thank you.
All right, thank you. And Donna Moore.
Thank you. I guess I felt a little old when I came here today because the dean told me that he never signed one of my paychecks when I taught here for 7 years. So I taught a trial ad class and a gaming law class. So it must have been like clearly before everybody's time and probably before most of the professors here apparently. But thank you for inviting me here, and thank you for holding the seminar. You know, I have been saying throughout my run for this office that the state's attorney has to prosecute crime no matter who commits it, and that includes gender-based violence. And it seems like a very easy statement, but it's a statement that we haven't been able to live up to. So we have to prosecute crime no matter who commits it, whether it's a he said, she said case, whether it's a case of domestic partners or husband and wife, whether it's you're white, black, or you're wearing a navy blue uniform. We have to do that. And we need a state's attorney who is willing to take on the tough cases and to preserve the evidence. It's not about convictions, it's about justice. And as Ms. Fox said in her remarks, we have a backlog of testing of rape kits because the difficult rape cases, the difficult he said, she said cases aren't being prosecuted. And just today, the office of Anita Alvarez dismissed a case against a member of the clergy because they failed to preserve victim testimony. So we have to be smart about how we prosecute, we have to be smart about how we preserve our testimony, and we need a state's attorney who isn't afraid to do what's right. Thank you.
Thank you. And for our first question, we'll start with Ms. Alvarez. In December of 2015, the Department of Justice issued federal guidelines to help law enforcement agencies prevent gender bias in their response to sexual assault and domestic violence, highlighting the need for clear policies, robust training, and responsive accountability systems. Under your leadership, how would the Office of Cook County State's Attorney undertake similar work?
You know, we have been, as I said, training all of our assistant state's attorneys, mandatory training, and we also train the police force. Because what we've seen, which has been so important, is that there has to be a working group, and we're part of a task force with the city, with the Chicago Police Department, to make sure that the victims are getting the responses that they're supposed to get, and making sure that our ASAs are competent and trained to do it. One of the things that I learned in my first election was the disparity with cases, how they were handled in the suburbs and in the city. I said we can't have that. We have to make sure that there's consistency, continuity, because that's so important. Because we, the victim, obviously, that's who we speak up for each and every day. So when these cases are looked at, not only do we have to interview the victim, we have to build our evidence, there's also forensic evidence. I'm part of a working group with the Attorney General's office to make sure that rape kits, that there's a better response from the Illinois State Police Crime Lab in testing these rape kits, because there's clearly a backlog. It's not just here, but throughout the entire state. Was that a stop? I wasn't sure if...
Nope, you still have 45 seconds.
Okay. So with that being said, we are part of a task force. We're part of a working group. With the changes that I've made in the office, it's clear that we're able to serve the victims of sexual assault and domestic violence in a much better position than we've ever had before. We still have challenges, as I stated in my opening, when it comes to acquaintance rape. Those are probably the harder cases for us to handle, but we have approved more of these types of cases than we ever have in the past. And I know the advocates that we work with, I have taken a lot of direction from what I've learned from them in making sure that our victims have the services that they need.
Thank you. And Ms. Fox, how would you undertake this work?
Certainly. I think training is critical, both from the advocacy standpoint, from the prosecutor standpoint, and from law enforcement. As the state's attorney said, if we are not consistent in the level of training and the understanding of best practices from the legal standpoint as well as from the advocacy standpoint, the inconsistencies cause issues for our victims. I think it's also critical to note that while there is training and extensive training, the 40-hour training that a number of ASAs do before they go to felony review unit, there's also in our juvenile justice unit a need for that type of training for those assistants who are there. We have cases, unfortunately, where our people who have been arrested and charged with sexual assault or gender-based violence are under the age of 17. We have a number of cases in which we have domestic violence issues where they are high school girlfriends, boyfriends, or the like, where the training needs to be done earlier and more expansively for those before they get to the felony review unit, because those cases are being evaluated and charged on an earlier basis. And quite frankly, in cases involving younger victims and younger folks who are being charged with it, the sensitivity about how we approach those cases, how we interview witnesses, and how we take into account the trauma and trauma-informed decisions that we make in approaching people who are involved in these cases is critical. So expanding that training, not just for assistants who are on their way into the felony review unit, having that training done earlier for those who are engaged in prosecuting these types of crimes earlier, and ensuring consistency and best practices between law enforcement, prosecutors, and advocacy is the approach that we would need to take.
Thank you. And Donna Moore, how would you take on this work?
Thanks. Well, we do need training. The question is are our assistants getting training? There was a report put out back in 2013 from the Battered Women's Network, which would have been about 6 years into the, or 5 years into the current state's attorney's term. And what this report found was, in fact, that state's attorneys in domestic violence courtrooms weren't being well trained. They weren't sympathetic to victims' claims. They weren't prepared for trial. They weren't subpoenaing the witnesses to be there and or the documents to either tender to the defense or to use at trial. These are comments coming from judges in the domestic violence courtroom. So these are very tough cases. I agree with everybody up here on that, but we have to make sure that the assistants that we're putting in the courtroom are up to the challenge.
Thank you. And we'll start with Donna Moore for this question. The advocacy community seeks to end the practice of arresting, charging, and detaining the victims of gender-based violence. Examples include trans women of color, prostituted people, victims of domestic violence who call for help or who defend themselves, or people who report sexual assault by police officers. Please share the policy steps you would take as state's attorney to stop criminalizing victims.
So, again, you have to prosecute people who commit crimes, but also understand who are the victims of crime. And so that requires that you have communication with the police department in whatever area it's in, and you also communicate to the assistants who are on felony review when they review cases that they can't be biased against transgender or sexual preference in terms of whether or not they're going to charge a case. And so what happens is that oftentimes victims feel like they are actually the defendants in a case, and that's a complaint that we hear both from police officers and from Cook County and by Cook County state's attorneys. So we have to make sure that, again, we have sensitivity training, we have training on what constitutes an offense, but we also have training on victims and victims' needs in the system as we go forward. Sorry, did I just hit the time? Oh, sorry about that. Okay. I have to get used to looking over here. But that we have folks in place, whether it's in felony review or in the Chicago Police Department, that are willing to listen and understand the special needs of certain communities in Cook County. And I don't think we have that in place right now, and we certainly don't have it in place when it comes to the Chicago Police Department.
Thank you. And Ms. Fox.
Can you repeat your question?
Sure. The full question, the advocacy community seeks to end the practice of arresting, charging, and detaining the victims of gender-based violence. Examples include trans women of color, prostituted people, victims of domestic violence who call for help or who defend themselves, or people who report sexual assault by police officers. Please share the policy steps you would take as state's attorney to stop criminalizing victims.
Certainly. I think one of the first things that we need to do is make sure that we have accurate data, being able to look at the data to see who it is that we're arresting and for what offenses is critical to ensuring that the policies and practices meet the need. As it relates to particularly trans women of color, what we know is that there is a higher, and again, the data would substantiate it with the ability to see it, a higher prosecution rate of the trans women of color as opposed to other populations in that demographic. Same thing with regards to prostituted women and those who are victims themselves of domestic violence. What we need to be able to do is be mindful of what the exact situations are, that just because you can prosecute something doesn't mean that you should. And so while I agree with Ms. Moore that you should prosecute no matter who commits an offense, the beauty of prosecutorial discretion is being able to look at the facts of each individual cases, determine whether there's a defense for the actions that were taken, to look at the totality and determine whether or not prosecution is necessary in those cases. But again, in the absence of data to determine how many of those cases in which an officer is called out to make an arrest and it turns out that the victim is also arrested, so that we can make sure that we're targeting our training to deal with how to respond to victims who are also engaged in behaviors in the midst of an action is critical. But we don't have that data to be able to ensure that the programming and training that we're doing is meeting the need. And so in order to address that, we would need to open the data and make sure our training is consistent.
Thank you. Anita?
I think what's important when you're reviewing any case that
3, 4, 5, 6, 7, 8, 9, 10.
Please let the candidates speak.
13, 14, 15, 16. 16 shots. 16 shots. 16 shots. 16 shots. We're with you, Anita. We're with you. We got you.
Please let the candidates speak.
16 shots and cover up. 16 shots and cover up. 16 shots and cover up. 16 shots and cover up.
Okay.
16 shots and cover up. 16 shots and cover up.
Y'all, we got you. We got you, y'all.
Cover up. 16 shots and cover up. 16 shots and cover up.
We're trying to have a different discussion here tonight about a really important issue. It's a really critical issue.
And a cover up. 16 shots and a cover up. Rakia Boyd was a young black woman who was killed by the police. Say what? And we gon' fight all day and night until we rest in peace. Say what? What side are you on, my people?
Yeah, we'll give it a couple
What side
minutes.
are you on? What side are you on, my people? What side are you on? We on the same side. Ronnie Man was a young black man who was killed by the police. Say what? And we gon' fight all day and night until he rests in peace. Say what? What side are you on, my people? What side are you on? We on the freedom side. What side are you on, my people? What side are you on?
So you all, we want to really continue this conversation about gender-based violence. This is an important issue affecting every community. So the college is asking if you want to be removed. So we might have to do that to continue this conversation. Thank you all. We're gonna continue this conversation on gender-based violence, okay? Okay, so there's a lot going on in the race for Cook County State's Attorney, and there's a lot going on in the city of Chicago. We want to talk about, sir, you're gonna have to submit your question like everyone else. We're trying to have an inclusive conversation. We're trying to ask all three candidates what they think. We're trying to ask all three candidates what they have to say. We want to take everyone's questions, and we're trying to do that in a respectful way that lets us really get at the heart of these issues. All these advocates are working on the ground every day on these issues, and we want this conversation to happen as well. So thank you all very much for your patience, and we're going to continue this conversation.
Thank you, Alicia. She is my enforcer. All right, so I will repeat the question again for you.
Thank you.
The advocacy community seeks to end the practice of arresting, charging, and detaining the victims of gender-based violence. Examples include trans women of color, prostituted people, victims of domestic violence who call for help or who defend themselves, or people who report sexual assault by police officers. Please share the policy steps you would take as state's attorney to stop criminalizing victims.
Well, when you look at any case, no matter what comes in the system, there is no cookie cutter for a rape case, no cookie cutter for a domestic violence case, no cookie cutter for a murder case. It's a case-by-case determination. And when you're looking at these cases, that's exactly what you're doing. And I am very proud of the office that I run and the fact that it is one of the most diverse in the nation. And I make sure that all of my assistants are trained. So everyone, no matter who they are, what nationality, what ethnicity, what color they are going to get the respect that they deserve from my office. When these cases come in, particularly when you're talking about domestic violence is complex, and I learned that early on as a young assistant state's attorney, and that's why I have a love and a passion for the work that everybody does when it comes to domestic violence. And they're complex, and you will see cases where a victim one day may be an offender the next day. So it's a case-by-case determination. Just last week, we rejected charges on 2 cases that CPD brought to us, asking for murder charges against women, against their partner. We rejected those cases. Why? Because there was a history of abuse there. There was clear evidence that the wrong thing to do would have been to charge those women with the murder. I'm very proud of that, and that's how we take on all of these cases. I have an LGBT liaison. In fact, she just got promoted into another position, so the new one is starting in 2 weeks. I always have a representative from the LGBT community. Why? For that very purpose, to make sure that I have a direct link to the LGBT community so that I can hear the issues and handle these cases appropriately. I'm proud of how we handle these cases. And race is not a factor when it comes to approving charges, ever. I don't care what the charge is, it is not a factor. And I'm proud of that as I sit here as the state's attorney. So, when you look at DV cases, when you look at sexual assault cases, there's a lot of work that has to be done, and we're going to continue to do it.
Thank you. And for the next question, we'll start with Kim Fox. For the advocacy community to understand how a prosecutor's office is addressing gender-based violence, they need data about charges filed, the number of charges presented and approved by felony review, the demographics of the parties involved, and the relationship between the offender and the victim. Would you require your staff to compile and release this data to the advocacy community in a regular, easily accessible way?
Yes, I think, again, as I said in my last answer, in order for us to ensure that the policies and practices that we're implementing are effective, we have to be able to look at the data to determine how and why we do the things that we do and the effectiveness of it. I mean, the issues around data in the state's attorney's office and the willingness to share that data and comply with FOIA requests have been a long-standing issue under the state's attorney's office. As we know, the Chicago Justice Project sought to work collaboratively with the state's attorney's office for almost 2 years as part of their sexual assault data practices and transparency task force. However, they were stalled because the unwillingness of the state's attorney to share the data that was being collected. Again, in an effort to make sure that anything that we do, you can't fix what you can't measure. And the way that you measure that is opening the data to make sure that it is clear and transparent. Transparency is what guides how you make sure that your practices don't have a disproportionate impact or a disparate impact. Not to suggest that race comes into every case when you're making a decision, but when you want to make sure that the impact is fair and impartial, the way you do that is by looking at data. So absolutely, we have to make sure that data is made available, not just within internally so that state's attorney's office knows it, but from the advocacy community as well, so that we can ensure that what we're doing is actually having an impact.
Thank you. And then Ms. Alvarez.
Can you repeat the question?
Sure. And this is about data for the advocacy community to understand how a prosecutor's office is addressing gender-based violence. They need data about charges filed, the number of charges presented and approved by felony review, the demographics of the parties involved in the relationship between the offender and the victim. Would you require your staff to compile and release this data to the advocacy community in a regular, easily accessible way?
You know, we in our office receive FOIA requests each and every day, which we answer. And I believe my office answers more FOIAs than probably any other governmental unit here in Cook County on a daily basis. So I'm not afraid of answering and sharing data that's appropriate. We have shared a lot of data as far as stats, the number of cases coming in. Sometimes there is sensitive when talking about specifics and victims' names and that sort of thing that we can't share. And that's something I think that's private stuff that we have, that's to remain. So to the point where we can share it, we have shared it, and we'll continue to share it. And I understand the importance of that, and I understand, advocacy community wanting to see those stats, and we have shared those. But obviously, every piece of information it couldn't be shared because of the sensitivity of the cases and victims' privacy.
Thank you. And Donna Moore.
Great. You know, transparency in the state's attorney's office is the way that voters and citizens of Cook County have trust in the office. And right now, I'm happy to hear what Ms. Alvarez says, but I have to disagree with her because I don't believe there is transparency in the office. And not only has the Chicago Justice Project sued the office, but the Better Government Association has sued the office for not giving out statistics such as number of felony cases charged, number of cases disposed by pleas or by trials. And in gender-based cases, it's hard to get that information as well. People aren't asking for names. People are asking for, as in your question, the number of charges, the types of dispositions, the demographics. That's information that should be given out because it's not about names and addresses. And if we don't give it out, and if we're not transparent, the public doesn't trust what we're doing. And I noticed that while agencies like the BGA don't get statistical information, which, by the way, internally in the state's attorney's office is a very good way to train your assistants. How do you know what you're doing with your cases if you don't keep track of? If the answer to a FOIA request is we don't keep track of this information, how can you train? How do you know what you're doing if you don't keep track of it? And in fact, there recently was something sent around, I think it was the Chicago Justice Project, although I'm not sure, that I know Ms. Fox and I signed in terms of being transparent and releasing the information that we could release publicly and to groups in order to keep a trust and in order to keep a free flow of information and a free flow of discussion of what the office is doing well and what the office needs to improve on. And the only way to do it is to talk about statistics, which we only hear when Ms. Alvarez is here.
Thank you. And Ms. Moore, we'll start with you for this next question. Should the state's attorney's office have a felony review unit? If you would maintain a felony review unit at the state's attorney's office, describe how you would structure the unit to encourage rather than shut down thorough police investigations and ensure that perpetrators of gender-based violence are charged with offenses that reflect the severity of their violence.
So the felony review unit is an important unit to have in the state's attorney's office. It's obviously where police and law enforcement come to get charges. But what that means is we have to have people in the felony review unit that understand elements of a crime, that understand how to charge, when to charge, what to charge. And as you go through the system, felony review is one of the early stops in your career as an assistant state's attorney. And so what we have to make sure of is that the people going into felony review, who are usually coming out of first municipal misdemeanor court, have real training about what it takes and what charges you're going to bring as a felony charge. And we have trial supervisors who are there. We have supervisors of the felony review unit. It's one of, as we can see from the recent cases, where we've screwed up, or I should say Ms. Alvarez's office has screwed up on the charging, that if you charge the wrong crime, you don't often get the conviction at the end of the day. So we have to have training and specific training on gender-based crimes, and that's not happening now.
Ms. Fox?
Thank you. Yes, I think we do need to continue with the felony review unit. Cases that are charged by the police officer need to be reviewed to make sure that we've complied with the evidence and the law. And so in order to make sure that, we've gotten a thorough investigation, when police officers bring those cases to the state's attorney's office, where they can review and they can make sure that proper protocols and practices are taking place, that the statement was done, in appropriate circumstances, whether someone asked for a lawyer and there were no violations of his or her civil rights, whether the evidence was gathered correctly, whether there was a need for more evidence. What we don't want to have is cases that simply go through without a thorough review that ultimately led to an arrest but won't lead to a conviction because the evidence has not been thoroughly vetted by an assistant state's attorney who knows how to deal with those cases. But it's agreed, that having a unit is only as good as the people that you have in that unit and the training that they have on the complexity of all of these issues. Again, in the felony review unit now, they do all manner of cases, everything from gun cases to burglary cases to violence cases, gender-based violence cases. And the way that we do the training for that, while there is the 40-hour training, I think there needs to be ongoing training specific to these issues, because building a case for a burglary is very different than building a sexual assault case, which is a sexual assault case is very different when you're doing acquaintance rape, as been talked about before. So there's a need for the unit, but I think you can do some specificity within the unit in making sure that you have people who are subject matter experts working with law enforcement to make sure that these cases get the attention that they need. But to not have a unit and have these cases go through only for those cases to not meet the legal burden and have a disappointment in justice for the victim of crime, I think would be a huge mistake.
All right, thank you. And Ms. Alvarez.
The felony review unit exists and it will continue to exist. And as I stated earlier, it was under my administration that I implemented the 40-hour training that's mandatory for all of my assistant state's attorneys. I've also instituted the mandatory sexual assault training for assistant state's attorneys before they get to the felony review unit. So they can't move on to that assignment unless they have that training. And that's mandatory across the board all over the county. In addition to that, what I've implemented since 2008 after I took over is that on every sexual assault case, it is being reviewed by the assistant on review has to call one of the special assistant state's attorneys from the sexual assault DV unit. So that assistant is calling someone from the specialized unit. If the decision is made to reject that case, then it goes one step further. Then it goes up to the supervisor of the felony review unit and the supervisor of my sexual assault domestic violence unit. So we've got multiple levels of a review, which didn't exist 8 years ago. I implemented that. Why? Because I knew that I wanted to do a better job on sexual assault cases. I wanted to do a better job on domestic violence cases. So there's a multiple level of review on sexual assault cases so that we can have that review when the case is charged and when the decision is made. And before it's indicted, it will be indicted by an assistant state's attorney that is especially from the sexual assault domestic violence unit. And the reason for that is the expertise. We want to make sure that that indictment is done correctly. We want to make sure the victims are getting the services that they need. We want the sensitivity there. We want to make sure that, if one person sees this and makes a call, that it gets reviewed to make sure that it is the right call. On domestic violence cases, we do more evidence-based prosecutions than ever before.
Thank you. And before we move on to the last question, just a reminder that we are taking audience questions. So if you have your white index card, make sure to write something down, find a volunteer in a white T-shirt. All right, so our final question before audience questions, and we'll start with Ms. Alvarez. An ongoing concern of many in the advocacy community is the practice of offering defendants charged with domestic violence, sexual assault, or hate crimes with a plea deal that allows the defendant to plead guilty to some other offense outside those statutes. Examples include rapists who plead down to misdemeanor battery, or a domestic violence offender pleading to disorderly conduct. What is the impact of that practice on the prevalence of gender-based violence, and how would you prevent the systemic problem of perpetrators being shielded from accountability for their true crime?
I think anybody who's done any work in domestic violence cases knows and understands that many times, and it's a frustrating part, I learned it early on, that victims many times don't want to follow through with the charges. That's frustrating, and I know there's advocates in the room and share my concern. With that being said, we have attempted to do more evidence-based prosecutions, so we're able to continue on prosecuting the case without the victim testifying. But that doesn't always work. Sometimes we are in a position where if the victim doesn't want to proceed and we can't convince her to proceed, then we're left with, what do we do? Do we go to trial? Do we lose this? Well, if he's willing to plead to something less, do you take that plea? So everything, again, it's a case-by-case determination, and it's frustrating if you can't proceed and convict on the charge that you officially charge them on. However, sometimes it's what's best for the case. Sometimes it's what the victim wants. Not always, but it could be that we lost a key piece of evidence. It could be we lost a motion in court, and so we're not going to be able to convict on the higher charge. So a lot goes into it. Without specific facts on certain cases, you really can't talk in generalities, other than the fact that the victim's wishes are always taken into account on any of these cases. And the case that Ms. Moore mentioned earlier, the victim did not want to proceed on that case. And again, it's frustrating for us because I didn't want to dismiss that case. But the victim did not want to proceed. So when you're left with that and the evidence isn't there, you have to make those tough decisions, to see what's best for the case.
Thank you. And Kim Fox?
Sure. Again, this is why data matters to answer that question when you talk about the number of cases that may have been charged as an assault or a higher level that were reduced down. If you don't have the ability to look at the data to see what the original charges were and what was ultimately pled down to or pled to, you can't see the scope and extent of what the problems may be. And again, the state's attorney is correct that these are case-by-case matters in which you have to look at the totality of the evidence and how you're going to be able to proceed and go forward. In some cases, it's absolutely right that if the goal is to seek justice and you can do it only by going down to a plea, it's rather better to have that conviction or that plea than to have nothing for someone who's been victimized. That absolutely makes sense. But again, what we don't know is if that's part of a broader practice. If it's not simply a matter of looking case by case, but a pattern in which we charge high and reduce low for the purposes of just getting that plea. Without having accurate data and sharing that data with the public, with advocates, so that we can know what was the charge when people came in, how did you charge it, and how did you plea, and is there a pattern when you do that, so that we can, again, address whatever training or evidence that we need or practices that we have to build out to make sure that we're building strong cases in the first place so that we don't have to plead them down. I think ultimately what you want to do is get the right charge out the gate and get a conviction for the charge that you've brought forth. But again, if 80% of these cases are being pled out, 75% of them are being pled out from that original felony down to a battery or the like, and we don't know how to address it because we don't have the data, that is a problem. And again, you cannot address a problem if you don't know the extent of it. If you cannot fix what you can't measure. And that is one of the problems that we have, particularly when it comes to these sex assault cases.
Thank you. And Donna Moore.
I want to talk about how it is that we prosecute these cases and why it is sometimes apparently in case-by-case basis they have to reduce to a lesser charge to get a plea deal. Because the problem is that domestic violence cases in particular are highly charged. It's not just a stranger committing a crime on another stranger. In these cases, you have emotionally charged people on both sides. So why isn't the state's attorney right now doing a preliminary hearing so we get our victims locked into their testimony? Why isn't she putting victims, when this happens, into a grand jury and getting their testimony so that if in fact a victim decides months down the road that they don't want to testify. And that goes to the time it's taking to charge a case and prosecute a case, which is a whole nother issue. So if we lock in a victim's testimony and they don't want to testify, we have a very good case to go even without the victim at that point. So there are things we can do to prevent having to plead to a lesser offense. They're just not being done.
Thank you. Thank you, candidates. Now we will turn to questions from the audience. We've gotten a number of submissions, so I apologize if we don't have time to get through everyone. And again, the candidates will have 2 minutes for each question. Our first one, what do the candidates think about adding hate crime charges to sexual violence offenders, especially for LGBTQ victims? And we'll start with Kim Fox.
Sorry, can you repeat the question? No, I apologize. I just want to make
Sure.
sure I'm understanding it.
What do the candidates think about adding hate crime charges to sexual violence offenders, especially for LGBTQ victims?
Got it. As we know, the hate crime statutes are designed and were put into place to ensure that we are not targeting communities based on whether it's gender, race, sexual orientation, to target them for crimes because it goes against our moral fabric. As it relates to sexual assault cases or sex crimes, I think we have to be mindful of the type of sex crime that we're talking about. Tacking on an additional charge of hate crime simply because of the class of the person of the victim without any substantiation of other facts related to that crime, I guess that's why I pause for a moment. In the same degree that, if there were, an African-American victim and an African-American defendant, do we tack on a hate crime there? It depends on the circumstance of how the attack occurred. I think simply attaching a hate crime, because it is, again, it's a high burden that we have to find, a high burden that we have to prove, and it has to have that intent involved. Simply because of the orientation of the victim may not make sense. I apologize if I'm not answering that correctly, but it depends on the circumstances. But simply because of the orientation of the victim, I don't think necessarily necessitates a hate crime designation absent any other facts.
Thank you. And Donna Moore?
So I agree with Ms. Fox in the sense that there are very specific things that you need to establish to prove a hate crime. And the mere fact that your victim may be a victim of color, may have different sexual orientation than the orientation of the offender doesn't necessarily mean that it's a hate crime. So you have to examine the case, again, in felony review, and have them look at all the facts, have them question. Part of the job and part of the way we get the best charging decisions we can is to actually have our felony review assistants question and re-question whether it's the victim, whether it's the defendant who's potentially giving a statement, or whether it's the police officers or other folks that are bringing the case into the office. And so if there's evidence of additional crimes to be charged to, and including a hate crime, then it should get charged. But you have to determine that when the case is brought into you.
Thank you. And Ms. Alvarez?
Any additional charges that you bring, you have to prove the elements of that crime. And hate crime, it has to be specific that the crime is being committed based on that person's race or their gender, or their ethnicity or their religious affiliation. So to say that just because a person is a person of color and they've been a victim of a sexual assault, you attack on a hate crime, no, you wouldn't be able to prove it. So it's a case-by-case determination. If you were able to prove the elements of a hate crime, if it was an appropriate case, then you would add it on. The other thing, whenever we talk about hate crimes, I think people don't realize that the statute, the hate crime is actually a lesser a class than most, the most serious cases. So if someone's being charged with an aggravated criminal sexual assault, adding on the hate crime as a lesser offense, it's the bigger offense is the actual act of sexual assault. But you have to be able to prove the elements of the crime. And if you can prove that this attack occurred because of that person's race, gender, ethnicity, or, religious affiliation, that's one thing. But if you can't, then there'd be no reason to charge it.
Thank you. And get ready for this one. It's got some good facts here.
We're going to limit these responses to 1 minute each, just so we can get to the maximum number of audience questions.
Okay, so now 1 minute. And we'll start with Ms. Alvarez. The question is, according to the Rape, Abuse, and Incest National Network, each year there are 293,000 victims of sexual assault, yet only 32% of sexual assaults are reported to the police. I think that that's 98% of rapists will never spend a single day in jail. What do you plan to do to increase the percentage of sexual assaults reported to the police and help to improve conviction rates of rapists?
Well, one of the things that we've been working on, which is really important, and that is our campus sexual assault group. And that is because what we've seen, the lack of reporting, particularly when it happens at a university on campus. And so we've been training here in Cook County, and Lisa Madigan, the Attorney General, is training across state, so we can improve on victims reporting and train the people at the university, the administration, how to handle those cases, because many times that's the problem. If you haven't, seen the movie, the Hunting Ground, I encourage you to do so because it's a little scary. Yeah, great, isn't it? And it's scary, when you watch it. Some of the biggest universities that are featured in there. But that is one thing that we're working on to improve the response by the universities, improve the way that sexual assaults get reported. And I think, there has to be education in schools so girls know to come forward.
Thank you. And Kim Fox?
Thank you. I'll pick up with the education piece. We do need to work on destigmatizing victims of sexual assault and sexual violence. I think part of the issue becomes, again, we have to also create a culture in which there's a presumption of believability when they arrive at your door and you build a case. I think what happens with a lot of people who underreport, or a lot of victims who underreport, is the assumption that there will be, that they won't be believed, that they don't have sufficient evidence to come forward. And that they will be re-victimized or stigmatized by acknowledging what's happened to them. I think, again, before we get to the college campuses, that we need a really aggressive education campaign around sexual violence and violence against gender-based violence earlier. Because, again, at the point at which some people don't go to college and we don't have a campus issue, we have, issues related to people in the neighborhood, and we don't have that venue of the college campus to train it. We need to do it earlier, and we need to do it around destigmatizing victimization of sexual abuse or assault.
Thank you. Donna Moore?
Well, just to reiterate, I do think that victims of sexual assault or sexual abuse are made to feel, in many, many cases, that somehow they did something wrong, that they're being treated like they're the defendant in the case, and that they're not getting the support that they need to actually come forward and tell somebody what happened, tell law enforcement what happened. So I think in order to encourage that, one, we have to just empower our young men and women in schools, that no means no, and if there's a problem, it's not their fault, and that they need to report it. But we have to do a better job initially of when they come into the criminal justice system of counseling. The other thing I think we need to do is to give them a better comfort level, that from the time they report the crime and we charge the crime, we actually prosecute and get a conviction on the crime, and that it's not going to take 2 or 3 or 4 years, as opposed to maybe 18 months.
And that's time. Thank you. And we'll start with Donna Moore again for this one. This one's from Twitter. How will you build trust in immigrant communities to increase access to justice for immigrant survivors of gender-based violence?
Well, part of the issue in immigrant communities is English isn't their first language. And so many times they don't understand the justice system here. They don't understand what their rights are, but yet they come from communities where certain things are more accepted, where violence between a husband and a wife or parents and children is more accepted. So we have to be able to reach out, and that means working with not-for-profit groups, because oftentimes we don't have a budget to be able to have translators to reach out direct to the community. But they have to understand what their rights are. They have to understand what's available to them in order to report crime. And that has to be done, I think, in cooperation between the state's attorney's office and working with not-for-profits in the community to be able to get that word out to our potential victims.
Thank you. And Kim Fox.
Thank you. New York has, and it's something that if elected state's attorney, I would implement an immigration court. And what that does is allow for the immigrant communities, particularly those who are undocumented, who tend to be those who are least likely to report their own victimization for fear of the repercussions or possible deportation, to be able to have a place in which they know that their cases will be heard and prosecuted without fear of repercussions for themselves. The issues in immigrant communities around gender-based violence are the same issues that we have across the board. What happens is the disconnect from the systems that are there to provide that service, largely out of fear of those repercussions. But certainly, I think it's one of those, because we know that we have a large immigrant population here in Cook County, because we know we have a large undocumented population in Cook County, there needs to be an aggressive effort, particularly as it relates to their victimization, to reach out to them and make our courts open to them to assist.
Ms. Alvarez.
As I stated earlier, since I took over, we have implemented and created the policy, and many of the other state's attorneys across the state have followed, and that is our policy concerning U visas. And just last year in 2015, we certified 323 U visas. We work consistently with LAF, with LAS, with Heartland Alliance to make sure that the victims are getting the services that they need. I have bilingual staff. Clearly, there are some, Spanish and Polish are probably the two we use the most. But we have bilingual staff to make sure that our victims are getting services that they need. In the immigrant communities, we know how important it is to be part of the community. I've created community justice centers. I've tried to expand them with no luck, but I have 4 presently, which really help in many of the communities because we are physically there in a storefront, in more of a convenient location than going down to our offices. So there's a lot that we do.
Thank you. And we'll start with Kim Fox for this one. There have been strides made in the law enforcement and criminal justice system as it relates to the response to violence against women. I'm concerned, however, that with the many changes within CPD, that there may be a loss of traction around how CPD addresses domestic violence within its ranks. What can the state's attorney do to address that?
I think that, again, the data shows that high-stress jobs, particularly jobs in law enforcement, we see higher incidences of domestic violence in those professions. I think we have to be mindful of making sure that not only for the victims of that violence, but for those who are engaged in these professions, that we have the services and counseling and the ability to address those within the department. And then also, to the point that was made earlier, if found to be engaged in criminal behavior, domestic violence behavior, that we must prosecute those cases. The belief that one can get away with engaging in domestic violence simply because he or she is part of law enforcement, again, allows for the further victimization of the victim, who knows that because of their partner's relationship to their job, that they will not get the justice that they need. There's an obligation of the state's attorney to make sure that justice is administered no matter who commits it.
Thank you. And Donna Moore.
Okay, can you repeat the question
Sure.
again? Yeah.
There have been strides made in the law enforcement and criminal justice system as it relates to the response to violence against women. I'm concerned, however, that with the many changes within CPD, that there may be a loss of traction around how CPD addresses domestic violence within its ranks. What can the state's attorney do to address that?
Well, the state's attorney can charge where appropriate, but again, this is a question of training of CPD. I'd like to see some joint training between the state's attorney's office and CPD. It's interesting when you look at, for instance, what's happened in the National Football League in basketball with training of the players of what domestic violence is about, how to be aware of it, and how to deal with it. I've been involved in a lot of those training sessions, and I think that that's something where the state's attorney's office doesn't have direct control over the CPD, but they certainly can communicate to them. They can communicate that they will charge, once again, whether it doesn't matter if you're wearing navy blue or not. If you commit a crime, potentially the state's attorney's office charges you. But it's about education, and it's about allowing training to go on by the state's attorney's office to educate them.
That's time. Thank you.
There have been great strides made within CPD when it comes to domestic violence, clearly much better than when I was handling cases as a young ASA. And we now have three detectives assigned to our domestic violence division and at domestic violence courthouse that never existed before. So clearly they have made some strides as to how they are looking at the issue and treating the issue. But when you're talking about within their department and how officers are treated who in fact are arrested and charged, and we do charge them. It doesn't matter if you're a police officer, but we do have cases that come through the system where the officer is the offender, and we're not afraid to charge those, and we'll continue to do that. Increased training within the ranks in themselves, and that's something CPD really needs to focus on. But I think we're on the right path. We are part of the task force with the mayor, with the city of Chicago on domestic violence. Again, that's a big step that they took, and it's refreshing to be part.
Thank you. And we'll start with Donna Moore for this question. One of the keys to reducing gender bias in law enforcement and treatment within criminal justice system is increasing the number of women in criminal justice. The state's attorney's office is a notorious boys' club. What have you done or can you do in your career to support and mentor women interested in law, criminal justice, and how can we work to balance gender ratio?
Well, it's hard to tell exactly what's going on in the state's attorney's office because we don't get statistics that tell us what's happening. But I think you have to make an effort, in your career to interview and mentor, whether it's, women, whether it's, frankly, anybody in the legal profession needs a little mentoring. But you certainly want diversity around the table. Because when you have diversity around the table, you get better decisions. And I don't care if it's women, I don't care if it's African Americans or Asians or whatever. And what you need to do, and we do this in private practice, we do this in the public sector, is you have to be a part of the hiring process and make sure that you're looking for the best and the brightest, but also a diverse group that's going to reflect the community within which they work. And again, we haven't been privy to the statistics in the state's attorney's office. We've just heard anecdotally that it's not good.
Kim Fox.
Thank you. I think there actually have been strides made in the number of women who are in the state's attorney's office from many years ago. I think, at the time that I was there, that it was almost 50%, and maybe more now, of the line ASAs were women. And as we look at the trends of women coming through law schools and coming into law enforcement in the prosecutor's office, I think we have come a long way. I think what we need to do is make sure, again, is that diversity is not simply at the line ASA level, but in policy-making decisions. Again, when we have diversity of thought, diversity of experience at the table, we have more robust policies that are reflective of the values of the community. And so when we talk about diversity, we want to be mindful that we're talking about diversity in the decision makers who influence policy. And that's where I think the evidence or the data is key in terms of where the women placed within the state's attorney's office and do they have decision-making policy or practice.
Ms. Alvarez.
Well, as the first woman state's attorney, I am not a boy, and I was never part of a good old boys club, and I'm very proud of that. The women outnumber the men in my office, 54% women, maybe even up to 55 now with our last hiring class, and I'm very proud of that. I am the state's attorney, so yes, I am in a policy-making role, and some of my top advisors are women. My director of hiring is a Hispanic woman. So we do tremendous things in our office. I think I'd like to see more police officers, more women, female police officers. That's what I would like to see. Because I think, particularly when you talk about domestic violence, and then my experience was, many of these male officers did not think it was a crime, did not want to make an arrest, did not want to bring that case to court. And I would like to see more female police officers on the street, more female police officers I'd like to see the next superintendent to be a female. I think that would be tremendous. So I'm proud of the number of women we have in our office.
Thank you. And Ms. Alvarez, we'll start with you for this one. This one's from Twitter. What, if any, intersection do you see between sexual domestic violence and police brutality? Sorry, that was sexual/domestic violence and police brutality.
What the connection between sexual assault and police brutality?
What, if any, intersection do you see between sexual/domestic violence and police brutality?
Well, we're talking about two separate types of crimes. Obviously, police brutality could come in many different fashions. I think they're both violent. They're all violent crimes. It's something that we make a priority in our office. I guess it's hard to answer that question. It's the inner, I don't know. I'm sorry, but it's kind of, unless you have.
No, I'm always only thinking that if we're talking about
Officers
police brutality who in an arrest in a sexual assault case.
Maybe,
But,
obviously we have had those cases where officers have been charged. Years ago, an officer had, forced someone.
Right.
And so we handle those, but it's kind of an.
Or unless sometimes you have the case where somebody comes in particular in some of the misdemeanor cases where they would come in on a prostitution case, and then the potential defendant tells you that there was some police misconduct prior to or after the arrest, but otherwise I'm not sure what the question's getting at.
Yeah.
Sure. Ms. Fox,
I'll take a try at it. I think we've seen, if not here in Cook County, there's been incidences in the news as of late regarding police officers who've abused their authority and power and committed sexual assaults amongst women in their jurisdictions, most notably the young police officer, I think his name was Holtzclaw, out of Oklahoma, who was just convicted of having raped, I believe it was 13 women during the course of his duties as a police officer. And so that is a sexual assault and a form of police brutality that, again, that was a glaring evidence of that. One of the concerns that we have, again, for police officers who would abuse their authority in that way is the victim's willingness and ability to come forward and report those incidents. I think what we found in that particular case was this was a police officer who preyed upon women who were prostitutes, who had engaged in drugs, and they were vulnerable, and making sure that we don't have police officers using their authority and their badge to prey on vulnerable people to commit these acts is critical.
Thank you. Ms. Moore, you kind of responded to that. Was that sort of your response already?
Yeah,
Right.
exactly. I'm trying to ferret out the question.
Well, then, Ms. Moore, we'll start with you for this one. And this is quoting the card. I'm hearing, quote, he said, she said cases, but good prosecutors say there is no such thing. There is always other evidence. How will you get beyond the rape myth of, quote, he said, she said?
Well, I think you have to do a number of things, and one is that if you have physical evidence, obviously that helps. If you have other kinds of circumstantial evidence, that helps. But as a prosecutor, particularly as a prosecutor in the Felony Review Unit, which is where the case comes in, your job is to question and question again. and make sure you have not only the evidence from your victim, not only the evidence from a defendant's statement, potentially if you get that, but also you have the police collect the evidence from the scene, and you have the evidence from a rape kit, hopefully. So those are things that you hope to have. Sometimes you don't have it, and you have to evaluate your case just on your victim's statement and on what the defendant may or may not say. And those cases are tough, but there are cases where you judge the credibility of your victim and you take the case to trial based on that.
That's the time. Thank you. Ms. Fox.
Thank you. Yeah, again, as I said earlier, a lot of these cases are not going to have a mountain of evidence behind them. A lot of what we know about sexual assault victims in cases is that it may not be reported immediately. It may be a couple days. You're not going to be able to do a rape kit. You're not going to be able to have DNA. What you're going to be able to do is sit down and talk to your victim and analyze based on what they tell you, again, after questioning, whether or not they're a credible witness. And you go in with the assumption that you're working with someone who's reporting a crime, not that they themselves are a defendant, and that you're not cross-examining them to trip them up to see whether or not they're filing a false claim. What we know, only 2 to 8% of reports have been false claims, which means 92% of those who come forward are filing cases that they are reporting cases that are actually cases that should be prosecuted. And so you have to go forward with the evidence. If you believe that you have a credible case, if you have a witness, that's what you do.
Thank you.
I think it goes back to training. Obviously, any prosecutor wants more evidence than just one word against the other, obviously. So you look for that outcry, you look for physical evidence. It isn't always there. But I think what's important is that, our assistants understand the trauma, understand what victims go through, so they can understand that trauma and understand perhaps why she didn't outcry immediately, or it took a week, or she didn't say anything to the first person that she saw. That's where that training is so very important, because you need to understand that, because it's easy to say, oh, she said this and she didn't tell anybody for 2 weeks, and reject the case. No, that's why it's so important that we have the training, so that we can put ourselves closer to that victim and understanding why she or he did or didn't do what she did, in order to build a better case.
Thank you. Ms. Fox, we'll start with you with this question. If chosen for office, what legal tools will you provide for victims to help them obtain orders of protection?
I think we need to be able to make sure that all of our prosecutors in domestic violence and juvenile court are trained on how to obtain orders of protection. I think there's inconsistency in if you go from some courtrooms to courtrooms in terms of who knows how to get an order of protection. I think secondarily, it's not necessarily a legal tool. We need to be able to offer wraparound services to those who are asking for orders of protection, because either if you're going to be removed from the home or you're having someone removed from the home, there are issues related to income, housing, counseling, and the like, that we want to make sure that in the means of escape from your circumstance, that you also have the ability to continue to maintain your quality of life while this case is pending. And so, it's not necessarily a legal tool, but making sure that we're offering, one, consistency in how orders are obtained, and wraparound services for those who seek to obtain them.
Thank you. Ms. Alvarez?
In domestic violence court, obviously when the cases come in as far as screening goes, if in fact, sometimes it is a criminal charge, sometimes it's not, and sometimes the victim does go for a civil order of protection. So services are there, and the fact that we work with LAF, we work with, Heartland Alliance, that helps tremendously. When we have cases in other courtrooms, obviously, we have been training ASAs on when to talk to the victim about an order of protection, what's important, and when they can get one, because they don't always understand when and how they can get one. Sometimes people think they can get one when they can't, based on the relationship. But some of the other thing I want to just touch on, when we haven't touched on it, so I want to just talk about it. The GPS, the Bishop Law. And just so that's something that we are asking for at bond court,
That is time.
and that's something I think that's important as well.
Thank you. Donna Moore?
So, I think it sounds like we're fairly in agreement on some of this as it relates to an order of protection. Obviously, when you have a victim who comes in and needs an order of protection, you do have to make sure that the victim, that in many cases the victim has children, that they are put in a safe and secure environment, that they have the ability to report to someone if in fact they do feel threatened by the defendant, who oftentimes is a spouse or a partner, and to make sure that there's counseling available, as well as counseling not only for the victim, but in many cases for their children who have probably been abused and also the subject of domestic violence themselves. I think one of the things we have to do is we have to work to make the speed of the time we charge to the time we go to trial better. Our assistants have to be ready to go to trial, because it's the lag time in between the
Thank
charging.
you, that's time. Thank you. That'll have to do it for our audience questions. Now each candidate will have 1 minute for closing statements. We'll start with Donna Moore, and then we'll come down the line and end with Ms. Alvarez. So 1 minute, Donna Moore.
Okay. Look, I think that our criminal justice system in general is broken. In particular, we have issues with how we charge and how we deal with sexual abuse and domestic violence cases. But people in this community and in this county have lost trust in the state's attorney's office because of cover-ups, because of failed charging, because of wrongful convictions that aren't brought to the attention of the public, and because there's a philosophy in the office of convictions over justice. And, the state's attorney talks about meticulous and thorough investigations, but if you look at the range of recent high-profile cases, I think that the agreement is that these cases have been far from meticulously and thoroughly investigated. And this includes, again, a lack of trust in not only the high-profile cases, but what are we doing in our cases day to day? Do we trust this office to effectively investigate and prosecute domestic violence and sexual abuse?
Ms. Fox.
Thank you. As this conversation has shown, the issues related to gender-based violence are pressing and compelling. And while not getting the news and the attention of the violence that we're seeing in our streets, the gender-based violence is more insidious and more difficult to prosecute. However, because of its prevalence, because of the number of victims, and truly the impact on our communities, as someone who's been a victim of a sexual assault, I understand the trauma that is lingering in our victims long after we try those cases. And because we understand that the incidents that happen, people who are victimized by this type of crime carry on with them for the rest of their days, we need a prosecutor who views each and every case, whether their names are famous or not, as not just for that moment in time, but being able to exact justice for them and make them feel whole so that they can go on and live productive lives, the victims, because we understand the full impact of the trauma.
That's time. Thank you. Ms. Alvarez.
As the Cook County State's Attorney, as I said in my opening statement, domestic violence, sexual assault has always been a top priority of mine, and I'm very proud of my record, because this office, when it comes to domestic violence and sexual assault, does not look like what it did 8 years ago, and it certainly doesn't look like it did when I joined it 29 years ago. Every victim is given the respect and the service that she or he is deserved when they come into this office as a victim of crime. We have evolved particularly when it comes to gender-based violence, and we're going to continue to evolve. And why? Because I've established a relationship with the people who are on the front lines of the advocacy community, and I listen to them because that's really important. I have to listen to the people who are in the front lines with the victims each and every day. I have learned so much. My assistants have learned so much. I'm putting people in these units who want to be in these units. And that makes a big difference in making sure that they are appropriately trained in order to handle the caseload
Thank you.
that they see each and every day.
Thank you. Well, that is our time, and the primary election is on March 15th, so thank you to Anita Alvarez, Kim Fox, and Donna Moore. I'm going to invite Alicia Tate back up for closing remarks.
Let's thank our candidates. Thank you. Thank you all so much.